for openings?
Ready, Your Honor.
Mr. Bates, you have the floor.
I'm going to try to pare this down as much as possible. The court heard a lot of the evidence, the anticipated evidence yesterday. The way the evidence fits together has taken me 18 months to understand. This will be helpful to show this is a legal nightmare. Innocent men, and Mr. Adams was found guilty in this court. This is the nightmare our system tries to prevent. Lawyers failed Mr. Adams. His defense, the prosecution, and at times the court, all of which the Constitution protects and preserves this final fail-safe to correct. We often think in criminal worlds that the Constitution allows guilty people to get out. We often don't think in terms of the Constitution protects the innocent from being wrongfully convicted. The court has said before, and it is very true, a lot of these facts are interwoven in multiple issues. I will say some things are standalone issues, which are constitutional rights that were violated that are now known, that were not waived. Additionally, there were constitutional rights regarding ineffective assistance of counsel. My suggestion is how I've interpreted this is wait until you find all of your facts before sorting out how the law applies to them. I want to show very briefly how all of this is going to fit together. And you're going to hear me say the video multiple times. And I'm going to get right to it to show you why it's so important. This is just a rough sketch that largely tracks exhibits that Mr. Reeves provided. I believe it's exhibit 140, where he maps out various cell phone maps, cell phone towers. 39077 is the northeast tower on the Birdsong Tower, northeast 7. That is incredibly important. There's Zach Adams' home tower, 3152, 31523 is Shane Austin's. 12572 is Parsons South Tower. I have on this, just for your understanding, in purple is the route that Marshal John Walker predicted, but due to ineffective assistance of counsel, he was not qualified as an expert at properly tracking. Mr. Adams' attorney, the night before Agent Walker's testimony, was drinking wine and flippantly preparing for Marshal Walker's important testimony that he laid out. This is in purple. Here's the important part. Marshal Walker says the victim did not move, her cell phone was not moving between 8:26 and 8:56. He predicted that's where her remains are going to be found, because that's where she was killed. He was right. Next to her, the victim's remains, is a 380. Remember that, I'll come back to it. A 380 shell casing. The cell phone then continued along a route that ended at 925, where the SIM card was thrown out along with everything else of the victim at 925 at Gooch Creek. There are two directions of travel from this route that goes in a clockwise direction leading to Terry Britt's home. Now, most of this information defense counsel knew. What defense counsel did not know is that there was a video of the Silverado in question at 11:12 a.m. that Zach Adams is prepared to say he was there. Multiple efforts, and I went into it yesterday. I'll just say this. The defense attorneys subpoenaed the bank for this video. The bank said, we've looked through our videos, we don't have it. There's multiple internal documents the state has now where the defense is told, you gotta get these videos. This is really important. The problem is, Ms. Thompson was told it was a BP video. And Agent Walker said it wasn't covered by the transaction of Shane Austin, was not covered by our videos. It's fair to assume nobody realized what they had. And you're going to say, well, why is it important? Because Zach Adams' cell phone was on the northeast tower at 39077 from 9:50 at 10:32 a.m. You're going to hear proof there was nothing uncommon about Zach and Jason Autry doing drugs under the bridge. We have, after realizing the BP video was the ATM video in March, we have spent enormous resources figuring out where along Autry's route the most favorable location on tower 39077 Autry and Adams could have been. What's the closest to where they have to go could they have been? We have a gentleman, Paul Dillon, who ran this route, according to Autry's testimony, as fast as he possibly can to go without real consideration for what had to take place that day, which is drop Autry off in the PT Cruiser, then pick up Austin, pick up his brother Dylan, change trucks, and get to the ATM at 11:12 a.m. It is impossible. Now let that sink in, Your Honor. This timeline is impossible. The route is not mere logistics. The route, and you say, well, wait a minute. I know from Exhibit 240, I know that Zach was at the northwest tower at 10:35 at tower 39079 and 10:36 a.m. and 10:37 a.m. And then at 10:38 and 10:43, he's at tower 31522. Exactly right. In 11 minutes, he went from I-40, Birdsong Northeast, to his home. And on the interstate, it's 10 minutes away. So if you're traveling on the interstate, Your Honor, you do not have a body in the back of your truck. And if you do not have a body in the back of your truck, no crime has been committed. You're going to ask, okay, what else do you have? Is there anything else corroborated by this? Same cell phone records. Shane Austin, tower 12572. South Tower in Parsons. He's there pinging from 11:15 to 11:52. Zach Adams, 11:16 to 12:10. This alone shows probable impossibility. But the cell coverage, and you're going to learn, it's not necessarily like a border where you feel that you're in a different cell phone the second you're in a different cell phone tower. It's not as precise. What is precise is what was mislabeled a BP video, which is the ATM video, which has them here. You have bank records where Shane was at the bank that was provided in discovery, that Agent Walker, again, of the 600 witnesses the state identified, Joe Walker was not one of them, the lead case agent. I assume because he has the records, and either he didn't know what he was looking at, or he was told to lie when he said that transaction is not covered by the ATM. There are multiple ways to show Jason Autry's testimony was a lie. Here's one, and this is just delicious. Part of this, anyone who grew up in the country knows a .32 revolver does not make the sound boom, boom, boom that Jason Autry said it made. Anyone ever been around a firearm knows that was a lie. So we employed somebody, hey, take a .32 revolver out, go under the bridge and shoot and see if it makes that sound. And it sounds like a cap gun being played in the backyard. Provided it to the state. On May 6th, the state sent their agents out to perform the same testing. And kudos to them. They brought something to read the sound. The cars were louder. That was provided yesterday at lunch, after the motion in limine on Mr. Autry's video. So that's the first point, how Jason Autry's testimony was a lie, that the state had the ability for 7 years to independently investigate, to say, wait a minute, this doesn't sound right. They waited until May 6th to do it. And kudos to General Boyano for disclosing that. But the fact that they tested that, and they've never tested this route, shows me either they haven't tested it because they're putting all of their chickens in the basket of, well, maybe Zach's not at the ATM. Or two, they've run it as fast and as many times as they can, and it's impossible to beat what Paul Dillon beat. And you're going to watch Paul Dillon's route. You have in this, wrapped in all one, prosecutorial misconduct for realizing, hey, even if they have Zach at 1116 in Parsons, you can't get from here to there, back, and then drive around Parsons. You have mislabeling the ATM, and here is, and Judge McGinley has been a family friend of my father's for decades. But when Jennifer Thompson requested a motion to continue, she said, she listed this, I believe, V8, which had been considered a BP video, among her motions to continue. Judge McGinley asked her, when do you want a trial date? She said, 1 year from the date Autry's testimony. Judge McGinley said, I believe the date you would select would be when pigs fly. You don't want a trial date. Now compare that to Judge McGinley saying at Mr. Autry's plea deal, your testimony was some of the most persuasive, credible testimony this court's ever heard. Judge McGinley believed Jason Autry, a man the state said is too dangerous to transport, over a fellow lawyer whose job was to defend Zach. You're going to hear how the state dealt with the other evidence. You're going to hear things about the TBI that's going to, you'll never forget it. You're going to hear the TBI in a letter saying that to the TBI, accuracy is not the issue. Consistency is. I didn't believe it when I read it. It'll make sense, though, when you hear the other evidence in this case. Autry's fabrication has this white truck being used and put in Victor Dinsmore's garage. And you're going to hear of Agent Brent Booth, who went to Indiana and said, I want to go over with you what Jason's going to testify and see if that helps your memory. That's 6 years after. 2011, Dinsmore's in Indiana in 2017. Booth says, Jason says this white truck was in your garage. Dinsmore and his wife, on recording, say, didn't happen. This is another point along the way where the state had the ability to say, okay, time out. Autry, you're lying. Accuracy is not the issue. Consistency is. So they continue on with Dinsmore. Finally, Agent Booth, and you'll hear it from him. He says, it helped me. It helped this case if we can nail all these little details down. Dinsmore asks, well, what's the chance of Zach getting out? Booth says, you never know what a jury will do. Dinsmore, on a recording that Adam's attorney never played to the jury, where she even had it transcribed, Dinsmore says, let's go with it. let's put the truck in the garage. You will hear fabrication of evidence of the worst kind. So bad, Agent Booth went back to him the next day and said, "Hey, I just want to make sure I wasn't putting words in your mouth." Final point, now sit down. The gun. In discovery, Dick Adams had a .357 confiscated from him that Jason Autry knew because he had had the discovery. Also, Shane Austin had a .357. One of those, or both of those reasons, is why Jason Autry told Agent Ferguson in IR 3152 that the gun employed that day was a .357. When Booth goes to Dinsmore, he says, "I just want to make sure, let's talk about the gun." Dinsmore says, "It was a .38 revolver with an interchangeable .357 barrel." And he's 100% true. What he tells Booth, 100%. And he says, "I know my guns." 6 days later, one other thing. Dinsmore said, because he's a felon, years ago, my wife threw away a .32 revolver. Six days after this, they find the .32 revolver. And somehow the coordination takes place before trial, where everybody says it's a .32 revolver. Their lie had been caught. The only thing they pulled out of the ditch was Dinsmore's .32 revolver. The victim, the defect in her skull was .36 in diameter. Then Prosecutor Nichols said to the jury in closing arguments that .38 is excluded. Next to the victim's remains is a .380 pistol casing. Would you like to know what the diameter of a .380 is? .355. The gig is up on this conviction. I take zero pleasure in presenting this evidence. My obligation is not necessarily to Mr. Adams, it's to the court who appointed me and the Constitution that requires it. These things are devastating to learn can happen in the system my family has spent practicing in since 1871. And I am sorry to have to learn this and present it. Thank you.
Thank you, Mr. Bates. Ms. Warwick?
Thank you, Your Honor. This smoking gun that Mr. Bates purports to bring to the court this week, this smoking gun of this route puzzle, the smoking gun of the time zones and the time frames and the where were they and what was going on, the smoking gun of Zach Adams and Shane Austin being in Parsons around 11:12, 11:15 until noon, guess what? It was shot at a jury, and they didn't flinch. Everything that Mr. Bates has shared with the court this morning was shot at the jury, and they didn't flinch. I think everyone in this courtroom, every state agency that has been involved in this case since 2011, that horrible, horrible morning, April 13th, that the Bobo family and this community and West Tennessee will never forget. Everybody that was out there will tell you mistakes were made. This was bigger than anything we had ever seen before. And the irony of it is how truly simple it really is. When you break away from all of the noise and all of the attempts of subterfuge and smoke and mirrors, because that's what this is based upon. Zach Adams stands before this court today presumed guilty. Guilty of murder in the first degree, guilty of kidnapping, and guilty of rape. And what this court is called upon to answer are two things. Were his lawyers deficient? His 3 lawyers, who among them had 100 years of experience, some of the best and brightest lawyers in the state of Tennessee, were they deficient? And if they were, and the state submits that there is no way that prong will be satisfied. If they were, for the sake of this interesting conversation that Mr. Bates wants to have, instead of a legal, factual argument based on the laws and the rules, if they were deficient, what difference does it make? Would any of this new, what the defense wants to call new, evidence make a difference? State submits to Your Honor that you are not going to hear anything in the next days, weeks, months, however long it takes. You will not hear anything that jury didn't hear. That those men and women of this community took into account in doing their job. How easy it is for jurors when we bring them in on the first day of jury term and they start figuring out how easy it is to get out of jury duty. Oh wait, I just have to say that and then I get excused. These men and women stood up as members of this community, raised their right hand, and promised to listen to everything. Not just a little bit, not just what Mr. Bates wants the court to hear and think about, but everything. So the state would challenge Your Honor to ask, would it have made a difference? Is it new evidence, or is it something the jury heard? And if it isn't something the jury heard, the state submits that the court will not be able to find any credibility with it, that it will be unreliable and unbelievable testimony. His lawyers were some of the most prepared, if not the most prepared lawyers that anyone has battled, and I submit anyone will battle in modern time. Jennifer Thompson alone, in just a 2-year period from September of 2015 to September of 2017, worked 2,600 hours alone on this case. She billed the state over $200,000 for her time and effort, and the biggest chunk of her effort was reviewing discovery, reviewing the evidence. They had a team of 16 people who rolled into Savannah for this trial. 16 people. Every request they made to Judge McGinley for extra resources was granted. They had a private investigative firm that billed the state $115,000 for their time. Jim Simmons worked 1,700 hours. Jim Simmons, who, if you ask anybody, will tell you is the greatest capital defense attorney in the state of Tennessee, sitting over here, representing the petitioner. Was counsel deficient? Absolutely not. They were the most dogged, relentless, zealous trio of lawyers that anyone has seen representing a defendant. But what they can't do is magic. What they can't do is keep the state from putting on the incriminating evidence that continued to pile and continued to pile and continued to pile against their client. The court also has to look to whether they had a plan. So what if you put in 2,700 hours if you're just flying without a goal? So what if you're just putting in the time and there's no quality to it, no intentionality behind it? They had the greatest defense possible, and it was delivered to them on a silver platter by the case agent in the beginning phases of this case, Terry Dicus, by the FBI agent who worked the case in the beginning phases of this case, Art Viveros, and from what Mr. Bates refers to as Marshall Walker, who worked for the Marshal Service and also was the one that went into the jail to interview Terry Britt and get a confession out of him, this seasoned law enforcement officer, and forgot to Mirandize him. That's kind of criminal investigation 101. The state would submit that when the court hears the timeline, the true timeline of the breakthrough in this case, which was 2013, 2014, Terry Dicus was off the case because he'd lost objectivity. Art Viveros was off the case because he'd lost objectivity. Marshall Walker was off the case. Those three were not on it anymore. Nothing had been done, and everything started to come together. As soon as they were out of the way, and the misguided, erroneous, destructive focus on Terry Britt took a back seat. The TBI did things in this case that they have never done before, things we only see on TV and in movies, to try to catch Terry Britt, because that's who Terry Dicus was focused on, at the expense of every other lead that was coming in. This defendant's name, Shane Austin's name, Dylan Adams' name, and Jason Autry's name were coming into the TBI in the days and the weeks that followed. But Terry Dicus wasn't having it. Terry Dicus wasn't having it. Because guess what? We got a sex offender that lives in the county. He's got to be our guy. They spent countless hours investigating him for nothing. They all got outsmarted by Holly Bobo. Most of all, this defendant. He got outsmarted by her, and he got outsmarted by his co-defendants, because they weren't all supposed to fold. They weren't all supposed to start talking. Nobody does that to Zach Adams. I run this county. I know these roads. I grew up here. Everybody's afraid of me. Nobody's going to talk because we all raped her, and we're all in on it. He got outsmarted by his drugged up foursome of co-defendants and by a tiny little blonde girl named Holly Bobo. She left scratches on him. Her test papers, she was studying for a test that morning, her test papers were found by Shane Austin's house. Her phone, her backpack, her property, her things. were scattered by these meth heads in the minutes following what they had done. We may never know exactly what happened minute by minute that day, but what we do know is what came from his mouth in the weeks and the months and the years that followed. Were his lawyers deficient? Heavens no. They brought zealous representation to a new level. And even if they were, was it detrimental? Was there prejudice because of it? Absolutely not. Because what no one wants to talk about is all of the other evidence that came into this courtroom, the smoking guns that the defense shot at the jury, and they never flinched. And at the end of it all, what cannot be lost in this is they kept him from death row.